Council, when you're ready.
Good morning. Can you hear me okay?
Yes, I
All
can.
right. Good morning. May it please the court. I'm Wendy LaQuasto of Fox and LaQuasto. I'm here today representing appellant Mr. Velasquez. I'd like to reserve 5 minutes for rebuttal.
All right.
This case is a bit unusual for me because, well, number one, I was scheduled third and now I'm scheduled second. So, but also because it's traveling with what's now the third case, which involves the same parties in the same litigation and has many of the same issues. I think we presented them in a slightly different way. So I think it's important that we both had oral argument to be able to present our ideas and try to make them more clearer than maybe our briefs did. So my case raises 4 issues, and it's our position that if you were to reverse on the first issue, which addresses the trial court's granting of Logitech's motion to dismiss for lack of subject matter jurisdiction, that you could decide the case on that. If you would reverse on that, I see I have some sun on my face. I'm sorry.
It's all right.
Things change as before the test that happened, right?
Right. No problem.
Anyhow, so our position is that if you reverse on issue 1, which has to do with the motion to dismiss based on lack of subject jurisdiction, that it would be unnecessary to even reach issues 3, 4, or 2, 3, or 4, which have to do with alternative methods to reverse based on status, situs, and the borrowed employee test. So I'd like to spend the majority of my time on issues 1 and 2. And I think I'd, and then maybe hopefully briefly address issues 3 and 4, depending on the time and how many questions y'all ask. So I'd like to begin by saying that it's our position that this case should have been considered as one for a motion for summary judgment and under that standard, and that should have been denied because that there are plenty of disputed issues of fact here, which would have made summary judgment improper. Under the first issue, it's our position that the trial court erred by granting Logitech's motion to dismiss because Mr. Velasquez's negligence complaint did not include any allegations given rise to longshoreman immunity. Consequently, Logitech's longshore immunity affirmative defense is something that should have been considered by a motion for summary judgment, not on a motion to dismiss. And because there were disputed issues of material fact.
Can you talk to us a little bit about the difference between an immunity defense versus preemption as it pertains to your argument 1?
Okay. Immunity defense is, it kind of gets raised in both places, but federal preemption is a situation where a complaint raises issues that implicate federal law, which Congress has said preempts state law. For instance, if he had alleged, I was working as a maritime employee and I was injured during the course of my work and I want benefits, then he would have made allegations that implicated the Longshoreman Act. And then Logitech could have said, oh, immunity under the borrowed employer theory. And Congress has clearly indicated that longshoreman is preempted. So that would be federal preemption. And under federal preemption, you have a lack of subject matter jurisdiction, and that can be decided as a matter of law. And then the case could be dismissed that way. When you're talking about tort immunity based upon longshoreman immunity that's raised solely by the defense as an affirmative defense, then it's not a matter of law kind of situation. Here, Mr. Velasquez's complaint has no information in it about longshoremen. He doesn't say he's an employee. He doesn't say who his employer is. He doesn't say he was injured in the course of scope of employment. He doesn't even mention any of the federal law or maritime or any of that. It's a simple negligence complaint. Logitech comes in and then says, oh, well, I'm his employee, a borrowed employer, and he was a longshoreman. And so I get immunity. But that can't be decided on a motion to dismiss. That raises issues of fact. And so immunity then, and your own case law, I maintain that the proper way to dispose of this case is to follow your own precedent in Walker, which I cited on page 21 of my brief. And that says that when a complaint makes no allegations, and in that case, it was workers' comp, no allegations of workers' comp insurance coverage, then workers' compensation immunity is an affirmative defense that cannot be raised by a motion to dismiss. And in that case, the complaint made no allegations about workers' compensation, but the defendant argued that the plaintiff said she was acting in the scope of her employment when she was injured. And they said that implicated workers' compensation, but this court disagreed. And they said that the defendant would be able to raise workers' compensation as an affirmative defense in an answer, and then they could file affidavits and seek summary judgment. And if there was undisputed facts, they could win that way. But if there weren't disputed facts, then it would have to be decided in a trial by a jury to resolve the disputed facts. So it's a difference, and maybe it seems kind of technical, but I think if you go back to how affirmative defenses are raised and pled under the civil rules, you can see you only get to raise, under 1.110, you only get to raise affirmative defenses if they're on the face of the complaint. Somehow you've made an allegation, for lack of subject matter jurisdiction that raises that immunity. And if the complaint doesn't have any of those allegations in it that would raise that lack of subject matter jurisdiction, then you're stuck with a motion for summary judgment, and you have to jump that hurdle to show there's no disputed facts and you're entitled to judgment as a matter of law. And I think
I just want to interrupt you just for a second, because I'm still trying to, get my mind around the concept of preemption, subject matter jurisdiction versus affirmative defense. So would I be correct? And, feel free to tell me no, but would I be correct in thinking it gets into subject matter jurisdiction if he was trying to claim he was entitled to the longshoreman benefits, and let's say Logitech came back and said, no, because you got state workers comp, so you're not eligible, and that would take it out of state court and into federal court. Is that right?
Yeah, if he was trying to make a claim for longshoreman in state court, then yes, then that would take it out of state court and that would bring it into federal court.
That's where we would be talking about preemption.
Right.
But if you're just asserting immunity because you think you have immunity because he's covered under this act, that's tort immunity. And that's
right.
The
That's tort
defense,
immunity.
and that's the difference.
And that's going to be a question, and that's generally going to be a question. I'm not saying it could never be decided on undisputed facts, but in this case, clearly there are disputed facts that, they're disputed. Everybody's disputing who his employer actually is. I mean, he thought he worked for Lanier and FreshQuest. He didn't think, that
Right.
Logitech was his employer. And he didn't even know what a stevedore was. He's just a guy working in a warehouse repacking pallets. He doesn't think he's a longshoreman. He doesn't even know what that is.
Right.
So, he certainly couldn't have entered into any grand bargain about being a longshoreman because he didn't even know what that is. So, and in this situation, I think, he's not claiming any sort of compensation benefits at all. He's already been provided state workers' compensation benefits.
Right.
He's already receiving all those. That's not an issue.
Did anybody provide the longshoreman benefits for him? My understanding is that none of these employers did.
No.
Whoever his employer is.
In fact, as I pointed out in my brief, I keep calling them Lanier, but they're this group.
Right.
Sierra, Lanier, Employers HR. There's this group that kind of all work kind of together, but they don't. The testimony from them was we don't lend out employees, we're low risk employers. So the people we hire aren't longshoremen. We don't get longshoremen coverage because our people are low risk workers. And so we just get workers' compensation coverage because, we're lending out laborers, or, like this was Mr. Velasquez was a warehouse worker. They didn't do that because that's not their business. And so they filed.
Counsel,
they
I
filed
had
their
made a
claim.
note in my record here that I think I got this from your brief, that Logistec had a policy of insurance that afforded longshore and harbor worker coverage through Signal Mutual Insurance. Were there benefits available through that policy or not?
Well, well, they said there were. And they did say that they had a policy, but I think it's really important to show that they've never even reported this. Never even reported the accident to their carrier. And the person that the witness actually spoke to was a broker, and it wasn't actually somebody that was that was representative of their carrier. So I don't really even know that that it can. I think it could be disputed, not really know that the longshore coverage is actually going to cover Mr. Velasquez. They said they had
so
it.
They haven't paid benefits so far through that policy?
They didn't even report it to their carrier. This is never, Logitech never reported it. They just let Lanier and all those people take care of them through workers' compensation. They sat on their hands about this and never made a report to their carrier, never gave any benefits. And then when they got sued, then they came up with this idea that, oh, wait a minute, he's a longshoreman and I'm a statutory employer. So,
Okay.
It's just not, I forgot to say when I started, I was going to write down.
How much do you want? 5 minutes?
No, I don't know how much time I have left.
You're at 11.
I
So
mean, at
you're
11,
good.
okay, so I'm sorry to be so discombobulated. I usually am at the first DCA and I got a little clock ticking right at me. So I guess I'll go to like 10:20. How's that? 5 more minutes? So,
Sure.
so I guess I'll try to do that. I'm sorry. I'm gonna, because I have used up 11 minutes and I was gonna do 15 for this, I wanna jump over to issue 2 unless you have any more questions on issue 1. Issue 2 is alternative, and we suggest that that it should be reversed because Mr. Velasquez fails the status test. And status means that there's a 4-part test, and one of the prongs of that is the person must have status, meaning they must be engaged in maritime work at the time of the injury. And he just completely fails that. He's not an employee within the Longshoreman Act because he's not doing maritime work. You have to remember Logitech's contract with FreshQuest was for stevedoring, but it also specifically included additional services, and those were described as warehouse and shipping operations. And that's exactly what Mr. Velasquez was doing, working in the warehouse. He was repairing pallets and damaged boxes after they'd already been unloaded by the ship by longshoremen and moved into this warehouse where the boxes could be stored for up to a week before they were ever shipped out to the end user. So he's just working constantly in the warehouse, pretty much always at this pallet inverter. It's undisputed he was never used to load and unload ships. In maritime employment, I know that Congress expanded it more inland, under Caputo, and they talk about that, but it was never meant to cover everybody who breathes salt air. And it certainly, all the cases say you have to be connected with loading and unloading or repairing ships, and he never did that. So he fails the status test, and that would be a reason to reverse in and of itself. He also fails the situs test under issue 3, which has a couple different prongs in it. It's also, everything's got super prongs, but that not only has a geographic element in terms of the site has to be near navigable waters, but it also has a function where the site has to be customarily used for loading and unloading. And Mr. Velasquez was injured in an abandoned warehouse. Yes, it was near the navigable waters, but it's an abandoned warehouse, condemned. It's not customarily used for anything. So by anyone. So, you certainly can't say that it's customarily used by by Logitech for loading and unloading ships. That's not it. So he fails the CITES test. And when you get to the borrowed employee test, which is my issue 4, and we've talked about Langford and Ruiz and whether it should be 3 parts or 9 parts, whatever. However you determine borrowed employee, it's still going to be under a summary judgment standard. Even Langford, that's exactly what it is. It's summary judgment. And there's all these criteria that you're going to look at, and how does a person fit into those criteria? And when there's disputed facts, it's got to be decided by a jury. And when there's not disputed facts, then maybe you could do it by summary judgment. But here, there's all sorts of disputed facts about who his employer was, who controlled him. He said that he took direction from Ricky Hosford, who's a Lanier employee. So and so I think that under issue 4, he's not it's not clear that he's a borrowed employee either to be a longshoreman, and that reversal would be appropriate under that.
You're down to about 4 minutes left.
Okay, well, perfect, because I always ask for a little bit more than I actually think I'll get for my rebuttal. So
right.
Unless you have any questions, I'll just be quiet.
Okay, thank you.
Thank you.
All right. Mr. Dono?
Good morning, may it please the court. I'm going to start by addressing what seems to be the crux of the case. It's the preemption defense. Now, if in the plaintiff's reply brief on page 4, she says, these statements of exclusive remedy and federal preemption are true when the injured worker is a longshoreman. Then at the same time, they say on page 6, it's not immunity. This case is not about immunity from suit. It's about a mere defense from tort liability. That is simply not true. And the reason why is because the Longshore Harbor Workers' Compensation Act is an exclusive provision. So the critical issue in the claim against Logistic here concerned the court's subject matter jurisdiction in the context of preemption. The U.S. Supreme Court.
The circuit court has subject matter jurisdiction over the tort lawsuit, correct?
It does not, because
Why?
It's
a state cause of action. It's a tort lawsuit. Circuit courts have jurisdiction over that. He's not making a claim for benefits under the federal law.
The plaintiff here does not need to make a claim for Longshore Harbor benefits for him to be a Longshore Harbor worker and for the act to apply.
So are you saying he's got to file his case, his case in federal court, his tort case?
That is correct. The
really?
case law,
his state law cause of action, he's got to file that in federal court.
I'll explain why. Yes, he has to file it in the federal court, because that is the court that has jurisdiction, subject matter jurisdiction, to hear these cases. The U.S. Supreme Court.
But here, when you say these cases, what do you mean?
Cases that are being asserted by a longshoreman.
But he doesn't say he's a longshoreman.
Well, he does not. The complaint.
There's nothing in that complaint that would implicate the Longshoremen's Act at all.
The complaint is artfully pled, and I'll explain why. I take the position, and I think it's clear from the case law, that once the person is covered under the Longshore Harbor Workers' Compensation Act, his only remedy, the statute says it itself. It says it itself. It's the exclusive remedy is to file a Longshore Harbor Workers' Compensation Act claim.
Well, we don't know if he's covered.
A negligence suit.
We don't know if he's covered.
Okay, so this is what.
So isn't that an affirmative defense?
It is not, because
he can't. He's covered. He can't sue us.
So if you take the plaintiff's argument that a Longshore Harbor worker can bring a suit in state court, what you would have is, let's say, the most typical longshoreman, which is the guy who's there grabbing the containers and taking them off the ships. He can now say, you know what, I'm not going to go ahead and file a longshore harbor claim. I'm going to go to the Florida state courts and I'm going to craft a complaint with no mention as to what I was doing, anything that would take me out of the onus of this federal preemptive statute, and bring a lawsuit in a Florida state court. Now, what plaintiff is proposing is, okay, at that point, the defendant, the longshore harbor employer, cannot challenge the fact the court has no jurisdiction, and we can proceed through a whole trial, a whole jury trial.
Wait, I am having a lot of trouble understanding how a Florida circuit court does not have jurisdiction over a state law tort suit.
Okay, it is because
You want to call it, you want to say, oh, no, he should be filing for longshoremen's, but that's not what he did.
he did it. He brought a suit which we assert is preempted by federal law, and that the court the court was correct. It had to first look at whether it could entertain this suit, because the cases say state courts do not have jurisdiction when the plaintiff acknowledges it.
Whether or not he's a longshoreman, isn't that disputed? I mean, he's taken the position he's not, and frankly, I read everything and I'm not sure, because yes, this warehouse is near the water. Yes, he works on these pallets, which aren't necessarily on the boat, but they're near the boat. And then you've got the accident, which happens even further away from the navigable water. He's on the phone, he's off in another building. I can see where the longshoreman provisions might be applicable if we could say as a matter of law, he's a longshoreman, but isn't that up for dispute?
I don't think so. The evidence was.
I mean, can that be decided on a motion to dismiss?
Yes, it can, because what the court here is doing is it's almost like an issue of personal jurisdiction. The court has to hold an evidentiary hearing to determine whether in fact it has the jurisdiction, the power to entertain this case, given the fact that this person is covered or falls under this.
Well, have you provided him coverage?
I'm sorry?
You didn't even contact the carrier. Your client didn't even contact the carrier. Has he been provided coverage?
He is covered under a policy of insurance by Signal Mutual for Longshore Harbor Workers Compensation Act. Now, the act, this is the thing, the act, you do not, in order for you to fall under the act and for the act to act as the exclusive remedy, you do not, the employer does not need to actually report or make a claim with the carrier. That's a non-factor.
How does the fact that he got state workers' compensation benefits affect his ability to get benefits under the Longshoremen's Compensation Act?
From my understanding, that's not preclusive. There's a proceeding, and I'm not an expert in this particular area of the law, but it's not preclusive. So you can file, from my understanding, you can file a claim in federal court. I mean, in the department, it'll be the Department of Labor, with the Department of Labor, and there is an adjustment made as to compensation, because I believe under the federal, under state, you may get more money, federal maybe less, so there may be some adjustment or vice versa. And so you're credited in the federal action, you'd be credited whatever he's received in the state.
Why don't you try to remove this to federal court if you think that's who has jurisdiction?
Because because the problem is there may have been other issues as to the parties in this case that destroyed diversity. But it's not even about.
No, you just wait. Who cares about diversity? You said that this is preempted by federal law and that his remedy is in federal court. So why can't you remove it? If the federal court has exclusive jurisdiction over this state tort lawsuit, why didn't you remove it?
I believe the calculus was that there was no diversity, and I don't think this was a question of. I don't think.
Well, if it's a federal case, why do you need diversity? If the exclusive jurisdiction for this is, as you say, federal court, why do you need diversity?
I don't think it raised a federal question, and I don't think that takes
Well, then
away
how is
from-
it preempted by federal law?
It's because it's preempted by the exclusivity of the act. And so,
Which is an immunity, which is an affirmative defense.
no, I don't believe it's just simple immunity. I think the case law is clear that it's
Okay, then why
exclusive.
can't you remove it to federal court?
Well, I believe Logistic chose correctly to move to dismiss the suit. Now, because,
You
for
didn't
example,
answer my question. Why wouldn't you remove it to federal court? If this is where it belongs, remove it.
I think the strategy that was taken at the lower court was to challenge the lack of jurisdiction of the court, and that was the decision that was made strategically. It was our position and continues to be our position.
Okay, let's say it should have been dismissed in the circuit court. So now what does he do? He goes down to the federal court and he files what? What does he file?
He could truly where this belongs is it's in the Department of Labor. He should file a claim with the Department of Labor. Now, if he chooses to file a suit in the district court, it would be based on, he could bring a negligence claim, and his suit again should be dismissed on the basis that the court lacks jurisdiction, given that it's the statute, the act.
Wait, the federal court would
precludes
lack
a court
jurisdiction?
claim.
Wait, the federal court would lack jurisdiction? Is that what you
Ultimately,
just
yes.
said?
Yes, because the act is exclusive. You can't bring a tort claim. A longshore.
So it's not even in federal court. It's not an affirmative defense. The comp immunity.
It is. It's you're precluded from suing.
Well,
Suing
you
your
just said
employer.
subject matter jurisdiction.
Well, because I think what the issue here is, and it's kind of getting mixed up. It's the fact
Yeah,
that
it's very mixed up. That's why I'm trying to understand it.
correct, and I'll try to explain as best I can, and I apologize if I'm not being as clear as I can be. My issue is that it goes right to the heart of the case, to the court's ability to hear the case. United States Supreme Court, the act itself, if you read it, it says this is the exclusive remedy. It precludes, it prevents a plaintiff from filing suit in a state court for tort. It just does. There's no way around that. And that's why we filed a motion to dismiss, because this court, this state court, and you have the Shives case that says it, state courts do not have jurisdiction, do not have subject matter jurisdiction over claims that are covered by the Longshore Harbor Workers' Compensation Act. They're exclusive, and it's preempted. Now, there were some other issues that were touched upon, which was, I believe, the once it's determined that there is a preemptive effect, or to determine that there is a preemptive effect, the plaintiff has to be a Longshore Harbor worker, has to be covered under the Longshore Harbor Workers' Compensation Act. And there's been efforts, obviously, to minimize what his role was at the port. But the record evidence showed that this was a person who was covered by both the status and also fell under the situs test. So he was integral to the unloading and to the unloading process of the vessel. And what plaintiff is trying to argue is what's been rejected by much of the case law, which is the point of rest theory, that once the cargo comes off the ship and at any point it touches ground or it's off the ship, that's it. The person, anybody who touches it after that point is not covered. It cannot be considered a maritime worker. Well, that's not true. That's been rejected by many Supreme Court cases. What you have here is a person that, as the containers were coming off the ship, or the pallets of fruit, he would operate a machine called a pallet inverter. And that was to fix the pallets, to make sure the straps were in place so the fruit wouldn't fall off. If there would need to be any repairs made to the actual boxes and the pallet itself, that's what he would do. The testimony is clear from several deponents at the evidentiary hearing that that was integral to the whole unloading process. Also, efforts to minimize the situs should be disregarded. Although it occurred at not while he was operating the pallet inverter, that is not crucial to determining whether he was covered by whether he met the situs test or not. The trial court was correct to find that the incident area was the same in the general and customary area used for loading and unloading. What we have here is a terminal, a marine terminal, that was surrounded by warehouses. The area was being used to unload and load cargo. So as the court stated in Coastal Products Services versus Hudson, the fact that the specific locus of the injury is not customarily used for maritime purposes, even though the general area is so used, is not fatal to a finding of maritime situs. So what plaintiff proposes is what's been rejected by the courts, which is almost like a hotchkotch thing, like, oh, if the incident happens in the bathroom, he's not covered. If this scenario, he steps away to use his phone while still being at the port near a marine terminal, the record says the area was only 80 feet away. There's testimony that says 75 feet. There's other testimony that says 80 feet away from navigable waters. You can't, he's covered. You can't have this entering in and out of coverage. That's the goal of the act, is to prevent that. And I believe I may be running either out of time.
You're about 15 minutes.
I'm sorry?
You're at about 15
Okay.
minutes.
So you can't be entering in and out of coverage, is to prevent that. So the court was correct. He met the status test, he met the situs test, and the other issue was whether he was a borrowed employee of Logistic. And that was, and there's a test, the Langford test, which was correctly applied by the court. That's a test that applies in determining whether the person is a borrowed employee. The trial court correctly applied the Langford test to determine that Logistic was the employer for the act's purposes. The test applies in determining whether a borrowed employer exists in cases arising under the Longshore Harbor Worker Act. It's not Florida state law. It's a case that's specific to determining whether a person falls under the act. First, the court found that he consented to the employment relationship. Now, how did he consent to that relationship? Which is an objective test. It's not a subjective test. It's not what Velasquez thought he was or he was working. He agreed through a staffing agency, Lanier, to go work at the port. He actually went to Lanier and said, hey, I want to work at the port. Filled out an application. He was contacted by Logistic and was brought into the port to work again in this crucial function of repairing pallets that were coming off ship for their eventual travel onto a truck and onto to clients. He had worked actually for Logistic before. There's record evidence that suggests he may have worked for them for almost 6 months before. The way this works is this temporary labor comes in, they work for about 6 months, and then there's an off period and they come back. It depends on the seasonality of the fruit. Upon his return to work, he was there for 2 weeks operating the pallet inverter. He showed up regularly, so he consented to the employment relationship. The second was logistics work being done. Obviously, he was hired to unload vessels, and in turn, logistics.
No, he didn't unload vessels.
I'm sorry, I may have misspoken. he was part of the unloading process. He was hired. There's people who unload the produce from the ships, and then it's brought onto the terminal by forklift. And then he would, at that point, collect the pallets, repair them, repair the boxes using this machine, the pallet inverter. So he was doing logistics work, which is to provide stevedoring services. And in this case is to take the fruit off the ship and get it onto trucks for its customers. And finally, it's whether Logistic assumed the right to control Velasquez's work. And the evidence here showed that Logistic only had the right to control Velasquez. They told him what to do, when to come, when to go. Logistic could terminate him from the job site. Logistic also furnished the place of performance, and in addition provided the tools. They provided the pallet inverter, they provided him with a vest that said Logistic, they gave him safety gloves, and Logistic would track his hours. They would write down when he came in, when he left, and then they would provide it to the staffing agency. And ultimately, they would write a check to the staffing agency for how much money or how many hours Velasquez had worked.
All right, that concludes your time, sir. Thank you.
Thank you.
All right. Ms. LaQuasto?
Thing. Okay, I was clicking the wrong thing. I'm always clicking the wrong thing. I think you said I had 4 minutes left, and
Yes.
so I will try to fit into that briefly. I think that it's important to understand that that all of Logistics' arguments are premised upon the assumption that Mr. Velasquez is a longshoreman. I mean, that's their assumption, and it's been their assumption all the way through, from the first time that they filed their motion to dismiss, to when they filed their motion for summary judgment, to their second motion to dismiss, to everybody that they had prepped and testified, and they said, he's a longshoreman, he's integral to the process. But that's not, those are disputed facts. And as I said, Mr. Velasquez didn't even know what a stevedore was. He's never used to load and unload ships. And really, that is the case law legal definition of what longshoreman is somebody who loads and unloads ships, that's involved in that process, or does repair work on them. And as I said earlier, he's stuck in a warehouse doing warehouse operations, and that's also part of Logistics contract. We didn't really talk too much about Trammell, but that's that evidentiary hearing case, and your DCA has the Hernandez case. And I think that when you look at those cases, you know, like Logitech wants to have an evidentiary hearing, and they cite those cases to say that that's proper, but those cases turn out the same way that this one should, in terms of it was an issue of fact about whether there was subject matter jurisdiction. And so in Trammell, they said it needs to go back through the regular process of the litigation process. And that's the same thing we're asking here. There's disputed issues of fact. It needs to go back through the process and all the way through trial in this case. And let's see. I also think in terms of for the Langfit case and the borrowed servant, that case comes up in a longshoreman scenario, and the reason that they shrink that test down to 3 is because of the grand bargain. You're a longshoreman, and so you've agreed to limit your remedies, and so, you know, we're going to do this abbreviated test, and it's not, and since it's disputed that he is a longshoreman, then we don't think that applies either.
Let me ask you one quick question. If it's determined through affidavit, testimony, what have you, that he is in fact a longshoreman, then would the Longshoreman Harbor Worker Compact preempt the state law claim?
If it was,
does this boil down to a matter as simple as somebody at a summary judgment level making a determination as to whether or not he's a longshoreman or not?
No. I don't think that under this case, under the facts of this case, that this case could actually be decided on summary judgment, because there's disputed facts about whether.
Let's set aside summary judgment. Is it as simple as determining as a matter of law that he is or is not a longshoreman? Do all the dominoes fall from there?
if it could be determined as a matter of law that he is a longshoreman.
Or that he is
then-
not. Either way.
Yeah, well, that would be decisive, wouldn't it? Either way. But
I mean, you're arguing that he's not.
and they arguing that he is, but and there's facts that support both sides, and that's why we say it's a disputed issue, and that's why it goes to the jury to decide. The judge doesn't get to decide those disputed facts at a summary judgment, at what became essentially a summary judgment hearing.
Well, I'm not prepared to go that far because I can envision affidavit testimony talking about this. This is the, the job involves the repair of pallets and we're this far from the navigable waters, et cetera, and the case law holds thus and such. I'm not so sure it couldn't be decided as summary judgment, but I'm also not convinced it's a motion to dismiss material.
Yeah, well, I mean, and that is our main point, is that it's not a motion to dismiss, that the court has subject matter jurisdiction, and because it's not a federal preemption case, there's questions of fact about whether he is a longshoreman, and those questions of fact have to be resolved properly. And a motion to dismiss is just not the way to do that.
All right, well, that concludes
Thank
your
you.
time. Thank you very much.
Thank you.
Thank you both.
We ask that you reverse. Thank you.
Thank you. Okay, we're going to call our next case, which is Manatee County Port Authority versus Velasquez. Counsel, whenever you're ready.